going to be referring to this document throughout my talk, so I think there's some copies floating around, or you can share. Thanks, Jay, for that introduction. It actually sets up my talk perfectly because I'm going to be speaking about NGOs and their role in the lawfare process. So we've heard a lot in recent months, the arrested attempts of Tzipi Livni and Ehud Barak in the UK last fall, and the current debate raging in the UK currently over their universal jurisdiction statutes have brought lawfare to the media spotlight, and I'm sure Joshua is going to speak more about that. But what is lesser known is the process leading up to these cases, the actors behind them, mainly a group of NGOs claiming to adopt the mantle of human rights and humanitarian objectives. And I'm going to speak a little bit about this process and who's funding these actors. And significantly, you might be surprised to learn that the European Union, many European governments, as well as George Soros' Open Society Institute, the Ford Foundation, and the New Israel Fund are playing a significant role in funding these efforts. Okay, if you take a look at the first page, you'll see a list of cases that have been filed against Israelis. It's not comprehensive, but it captures most of the major cases. It began in 2001 against Ariel Sharon in Belgium, and they've been continuing right up until a couple months ago, and right after the Operation Cast Lead, several Palestinian NGOs have claimed that they are preparing over 1,000 cases to file across the courts in Europe. Now, there are many things in common with these cases. You have both civil and criminal cases. You have, they're organized by the same participants. And most importantly, they're brought over pretty much 3 different events. The main event is the 2002 targeted killing of Hamas leader Shalach Shahada, who was responsible for the murder of hundreds of Israelis. And at the time of his death, he was planning many more attacks. Cases brought against Israel's security barrier, which since its construction has resulted in a drop of more than 95% in suicide bombings. And then, of course, last year's Gaza war. The claims are generally of war crimes, crimes against humanity, and even genocide. And they're asking courts to basically micromanage targeting decisions and would require the release of much classified military intelligence. If you take a look at the next page, as we've heard, it's not just cases against Israeli officials or those doing business with Israel. We have libel suits. NGO Monitor, in fact, has been targeted for this type of lawfare. Happily, a case that was brought against us in Israel was dismissed by the court last week, and the plaintiff was actually fined for its frivolous lawsuit. Palestinian organizations have gotten together to also attack Jewish organizations for collaboration in the occupation. They've taken steps to try to take away charitable status of Jewish or pro-Israel organizations. In Canada a few years ago, there was an attempt to take away the charitable status of the Israeli Red Cross. And these cases also share many other characteristics. They do not exist in a vacuum. They're part of a concerted strategy. On the next page, I outline some of the aspects of these cases. They're a form of soft power. They're generally, the people promoting these cases have a post-colonial and revolutionary ideology. They're anti-state, anti-democratic, anti-American. The victims in these cases are defined politically rather than by their practices. There's disregard for the rule of law, so we see massive forum shopping. For instance, the case brought by Palestinian Center for Human Rights regarding the Shahada targeted killing has been now litigated in Spain, the UK, New Zealand, Switzerland, the US, in Israel. We also see that in there's a case in Canada against several Canadian companies that are involved in construction in the West Bank. And the plaintiffs in that case have actually brought about 10 cases in the Israeli courts and have actually prevailed in those cases. Not in all of them, but in some of the cases. But yet, they are also bringing these cases abroad. There are often links to terror. Some of the organizations bringing these cases have links to Hamas and the PFLP. And the intention is to limit anti-terror operations, to prevent future operations, and to limit the right of self-defense. The legal goals are to greatly expand the boundaries of international law, to promote radical interpretations of international law, including war crimes, proportionality, the principle of distinction. They often try to supplant the laws of armed conflict, which are the lex specialis, when you're dealing with conflict areas, with that of human rights law, where the standards are very different and much more stringent. And probably the primary benefit of these cases for these organizations is the propaganda effect. All of these cases that I listed before have actually been dismissed in the courts, and most of them have been upheld on appeal. There's one case now that's currently pending. And they know that. They know that there's very little chance of these cases succeeding, but the goal is actually for the publicity and to link the state of Israel with that of a war criminal. And again, we see bias. We don't see any cases against the leaders of Hamas, Khalid Mashal, Hezbollah, nothing against their patrons, Iran or Syria. No cases on behalf of terror victims, Israelis or victims of 9/11. The strategy to bring these cases was crystallized at the NGO Forum of the 2001 UN Durban Conference against racism. 1,500 NGOs gathered and adopted a resolution declaring Israel the singular violator of human rights and international law. And on the next page of the packet, you'll see some of the statements from that resolution, including, we declare Israel to be a racist apartheid state, in which Israel's brand of apartheid is a crime against humanity. And they called to set up a war crimes tribunal to try the state of Israel. And Amnesty International and Human Rights Watch were active participants in this conference. Later on, they backed away from it, but they were very active leading up to it, and they were active in the process. This strategy underpins boycott, divestment, and sanction campaigns against the state of Israel, and as well as these lawfare cases. Since the 2001 Durban Conference, we have seen this strategy executed on many occasions. In Jenin in 2002, with the ICJ case against the security barrier in 2004, and the Lebanon War in 2006. And the pattern is always the same. Israel is faced with a spate of terror attacks. At first, it responds with limited means or not at all. The attacks often escalate, and eventually Israel engages in a full military operation. Once that happens, we see countless condemnations from NGOs, mostly against Israel, a few against Hamas or Hezbollah, but not many. And they purport to invoke international law, making accusations of war crimes, collective punishment, crimes against humanity, genocide, and the intentional targeting of civilians. These claims are based on little to no hard evidence, and they're largely adopted by the media and the international community without any independent verification. The UN then gets involved, particularly the politicized organs such as the Human Rights Council, which engages in further condemnations, calls for international investigations and war crimes trials. NGOs are then very active in that process, working very closely with those investigations. Along the way, the Israeli due process and justice system is denigrated, even though in the Israeli courts there are actually no limitations, no standing or justiciability limitations for people who believe they've been wronged to file cases there, including Palestinians. They have complete open access to the Israeli Supreme Court.